instead at the morning session. They're both going to give you some presentation about the legal updates, the legal landscape of federal and state, local fair housing, legal issues in 2024. And after that, we should have some time for some questions. As was mentioned before, just so everybody can be reminded, this workshop, this summit is about fair housing, not just affordable housing. So we're focused on bias, discrimination, disparate impacts to protected classes. And we would hopefully, for the entire summit, would like to end the summit with policy recommendations to advance the cause of fair housing. So if you have questions, comments at the end of their presentation, please feel free to offer suggestions about policy recommendations as well. And with that, I'm going to hand it over to the esteemed Tim Moran for his presentation. Thank you. Oh, and one last thing for everybody, because we do want to be inclusive too, please, if you're going to ask a question, offer a comment, and for the speakers as well, please self-identify yourself before you ask that question or speak. So, and with that, once again, I'm Brian Toskowitz, and ladies and gentlemen, Tim Moran. Thank you.
My name is Tim Moran, and I work in the Justice Department in the Civil Rights Division, and it's great to be here. So let me just ask a couple questions. How many of you here work in fair housing organizations? Okay. And how many of you work in in the housing industry in some way? Okay. And of those, how many of you are realtors? Okay. And property management? Okay. Lenders? Okay. Well, thank you. That's good to know. Obviously, you know, where one lives is extremely important. It determines where you wind up, what your job opportunities are, what kind of schools your children are able to go to, and many other things. I want to first just acknowledge that all of you who are in this room are here because you are trying to help that situation, either by finding good opportunities for your clients, providing good loans for your clients, or assisting people whose rights have been violated in that respect. I'm supposed to talk about legal updates, but because I kind of do what I want, and I'm an attorney, I'm going to more focus on some recent cases that the department has brought, rather than a laundry list of cases and matters. But I wanted to just start by that because I wanted to tell you that I will be giving you some examples of some housing providers who do not come to seminars like this, and we sue them. So, but I recognize that the people, not because they don't come here, but because of what they do. But I just want to recognize that I understand that the people in this room are not the people that do those kinds of things, but hopefully some of this will be helpful to you in knowing how to spot things and how to stop problems that you might be having in your own company, even if you don't get, because from people that are working for you. So, yes. So what I'm going to do, just click through all of them rather. Yeah, right. So what I'm going to do is I'm going to go. What I'm going to try to do today is really three things. I'm first going to give you a brief overview of what the Justice Department's role is in fair housing, and then I'm going to talk to you about some recent cases that we have been involved in. And then I am going to give you some examples of some recent guidance that we have issued in the area of automated background checks and tenant investigations, and that might be helpful to you. Okay, if you just go to the next slide. Okay, So the first thing you might be wondering is, what does the Department of Justice have to do with fair housing? And when I talk about the Department of Justice, I'm actually talking about two things. I'm talking about the Civil Rights Division, which is where I work in Washington, D.C., which enforces the Fair Housing Act, the Equal Credit Opportunity Act, and other statutes that affect housing. And I'm also talking about the local U.S. attorney's offices in every jurisdiction, which here, of course, in Detroit is the Eastern District of Michigan, and we have Shannon, I saw you. Yes, and we have three assistant U.S. attorneys, at least, from that office here today, and they are and some of the matters I'm going to be talking about are ones that they actually did. So where do our cases come from? If you could go to the next, yes. So there's two, really essentially three ways that we get involved in enforcement actions. One is when a complaint is filed with the Department of Housing and Urban Development alleging discrimination. Now, many of those complaints are referred to the local substantially equivalent agency, which in this case is the Michigan Department of Civil Rights. But if in a jurisdiction where they don't have such an agency, or for whatever reason the matter cannot be referred, it will then be investigated by HUD. And HUD will try to resolve the case, and if it determines that there was likely discrimination, then it will issue what is called a charge of discrimination, and then that matter will be litigated before an administrative law judge, unless the person, either the person who is complaining of discrimination or the person who is accused of discrimination wants to have the matter decided in federal court. If that happens, then HUD refers the matter to the Department of Justice, and the Department of Justice, either through us or through the U.S. Attorney's Office, will then file a complaint on behalf of the aggrieved person and basically pursue that individual case on their behalf, usually within 30 days of the charge being issued. So those are the individual complaints, and the other way that we bring cases is really just by identifying them ourselves and bringing them as what we call a pattern of practice or a group it's something that's systemic, something that's either a pattern of practice of discrimination or a denial of rights to a group of persons. Sometimes we get those as referrals, like from a local fair housing group like you. Sometimes someone complains about it. Sometimes we find out about it ourselves. So that is another big source of how we bring our cases. And then the third thing that we do that for the non-lawyers you may not be as familiar with is we also sometimes participate in cases in which we are not the party, but the case involves a legal issue or something that is important to us, and we want to tell the court about our perspective on that issue. And so we file what's in the district court are called statements of interest, and in the Court of Appeals are called friend of the court briefs, and in which we address those limited issues. So those are three ways. So I want to start by now going over some examples of what we do. And the first I want to talk about is the sexual harassment initiative. And I'm going to start by just telling you a brief story about a young woman who, in April of 2020, just after the pandemic had started, was looking for a house for her and her 2 young children. And she found a home in Dearborn Heights that was within her price range, in a good neighborhood. She talked to the owner. The only problem was that even though the rent was affordable, the owner told her that she was going to have to, that she would have to pay $2,100 to move in, including the security deposit and first month's rent. And she told him, well, that's going to be kind of tough, but I might be able to bring you $1,400. And he said, well, let me look into it and I will get back to you. And so he seemed very nice. She left. She, a little later that afternoon, got a text from the gentleman, and she was excited to see that at first. And he said, you know, a lot of people are interested in this, but I'm trying to work with you. You take care of me, I'll take care of you. She thought, that's kind of odd, but she thought, oh, he's just trying to help. And so she said, well, thank you very much. I will be able to bring by a check for $1,400 if that will work. And then that's when things took an odd turn, very odd. He then said, you're not getting it. Let's have some fun. Nobody has to know. And then, just in case she wasn't clear, I want to do you. And this is all on text, which she preserved. And that was essentially the facts of one of the incidents in a recent case that we brought in this district, United States versus Hussein, that the U.S. Attorney Office brought, where essentially we found that this was not the first time that he had done this. This was a common thing that he had done, where he basically people would come by and then he would later text them and offer to trade sexual favors in exchange for lowering or waiving the full security deposit. And sometimes he would also ask for pictures. We ultimately were able to settle that case with a consent decree, which is standard to what we usually do. He had to pay a total of $190,000. And in addition, and this is like very important, he is required he cannot manage, he has to, to the extent he continues to own property, he has to retain someone else to manage it, and an independent property manager, and he's permanently barred from ever participating in rental management again. One of the things he told us was that, I think he thought this would make us feel sorry for him, is that because of this case, his wife had left him and he had to get a divorce, and he lost half his net worth, and we were very sorry to hear that. But that is an example of the kind of an initiative that we actually, we've been bringing these cases for years, but in 2017, we actually formally started a sexual harassment initiative, which aims at basically making a real effort to identify these kinds of discrimination that is happening. We have a lot of, we have a complaint portal where people can contact us directly about these things, and we do roundtables all over the country with law enforcement and legal services offices and others to increase, and housing authorities to increase awareness of this. And the result is that we have brought, I don't remember the numbers because they're up there, and but we have brought even just in that time, we have brought many cases, just since 2017, we've achieved almost $17 million in monetary damages through these cases. Now, the other case that I wanted to emphasize is one that was just tried by our U.S. Attorney's Office in Massachusetts, and this involved a sober home operator. And usually, we are often bringing cases on behalf of sober homes because they often face discrimination and with neighbors trying to keep them out of the neighborhood. But, you know, like everything else, not all of the operators, some operators are better than others. And this particular sober home operator, to the extent that's what he really was sexually harassing the residents of his homes. And the jury just returned a verdict of $3.8 million, which is the largest verdict that the Department of Justice has ever obtained in a fair housing case, and it's certainly one of the larger ones. So that's the sexual harassment work. I want to talk a little about fair lending. That's another area where we have where we have an initiative, and we have specifically the Combating Redlining Initiative. It's a concentrated effort to identify instances in which lenders are basically refusing to provide the same level of service and lending opportunities to communities of color that they are to the rest of the areas that they are obligated by the Community Reinvestment Act to serve. And we have brought, since we started this in 2021, and since then we've secured more than $100 million in relief, and we have brought cases in just that period of time in at least 10 different states and geographical areas. Though an example is the one we filed just 2 months ago, in February, which involved banks in Charlotte and Winston-Salem, where almost all of their branches and mortgage offices were in predominantly white areas, and that's where they were originating almost all of their home mortgage loans from. And as a result of the consent decree, they are going to pay almost $12 million in loan subsidies that will be targeted for people in those neighborhoods that they had not provided service to. And then they will also be investing almost $2 million in those communities through credit counseling and other community partnerships. Another area that we are looking at is appraisal discrimination. And here's an example of one of our statements of interest that we filed. This was a case in Baltimore. We didn't bring it, but the Connollys, who live in Baltimore, were refinancing their home. They applied for a loan, applied for refinancing, were pre-qualified, but the appraiser wound up evaluating their home as less than $500,000, and they thought that was very odd. They didn't think that was right. Ultimately, they wound up getting another appraisal from another lender, and because of that low appraisal, they didn't get that loan. And they wound up getting another appraisal from another lender that was almost double the amount. And they allege, as there's much evidence of, that the appraiser undervalued the home because of the neighborhood, which was black, where they, because of the nature of the neighborhood where they were living, and also that they are black. Now, Nathan Connolly, who is an interesting person. He's a professor of history at Johns Hopkins. And can anyone guess what kind of history he studies? Yeah. He actually studies the history of housing discrimination. Yeah, he has actually written a book about the housing, about segregation in Miami, and is one of the leading scholars in the field. And so, of all the people they could have picked to do this to, that was not their best choice. But poetic justice, I suppose. But anyway, we did file a statement of interest there to make the point that a lender could be liable if they, even though the lender didn't themselves do the appraisal that was discriminatory, the lender relies on an appraisal to deny a loan, and it knows or should know that the appraisal is wrong and discriminatory, and it doesn't use its reconsideration of value process or other methods to either do a do-over or increase the value, then it can be liable because it is essentially adopting and ratifying the decision. And so I think the last thing I just want to mention is tenant screening and automated systems. That is really an emerging area. It's not necessarily AI, although some of it you might classify as AI, but it's basically the issue of basically that now landlords are often relying on tenant screening companies to basically tell them whether the tenant is someone they should rent to. And they may be considering all kinds of information that is either not accurate or not really relevant to whether they can afford the apartment, and some of the things they are considering, such as credit score or the criminal records or other things, may have a disparate impact on persons of color. And we recently issued 2 documents about this. There was a joint statement on enforcement efforts by a number of agencies that was issued just late last year, and that is on our website. And then we just issued in March a more user-friendly document that's more aimed towards consumers about tenant background checks and what their rights might, what persons' rights are, and what they can do if they suspect that there is a problem with the way in which they were denied an apartment. So I'm going to turn it over to Steve, but my contact information is in your materials, and at the end here. We often wind up learning about cases from people like you who tell us about things. So please don't hesitate to call or email me if there's something you think I can help you with. And I look forward to meeting you all later. Thank you.
We learned something about the DOJ. They're at times a home wrecker organization too. I never thought that would happen. But seriously, there tends to always be developments. Our center for over 20 years, we participate in Professor Moak's urban planning class, and on an annual basis to go in and make things. And so Last 5, 6 years, I was just doing recent developments in the last year, and you know, we're in the movement, we're in this every single day. We don't necessarily see that there are changes, but every single year, from year to year, there are significant changes. There really are, and it's not a static field. Problems occur, new situations arise, new techniques need to be explored. So it is really important. It's always good to be current, obviously. I don't know if the PowerPoint can go up. First off, legislative fair housing updates in Michigan. Michigan passed in the Act, Public Act 6 of 2003, added sexual orientation and gender identity and expression expressly under Elliott Larson. That protected class categories applies across the board: housing, employment, public accommodation, education. I think those are the main divisions. Also, few months later, it added a definition of race. It may be surprising to a lot of us that protected class categories are not defined in fair housing, for the most part. Disability is very detailed, familial statuses, but many other protected class categories do not have definitions. So it defines race to include traits historically associated with race, including but not limited to hair texture, protective hairstyles, including protective hairstyles, braids, locks, and twists. To back up on sex orientation, gender identity, that's already been prohibited. DOJ policy and HUD policy dating back to, 2013-14 through court cases, HUD v. Toon, and then it's been consistently applied that way, but this just makes it express. But getting back to race, the Dove Foundation started a movement toward having protective hairstyles or having them protected. It's been adopted by a number of states now. I think it's hard to get the number, probably over half, and it came real rapidly. Where fair housing or civil rights rarely happens fast, but it did in this situation. HUD estimated that there would be, this is a 2022, there was a bill proposed in Congress, it didn't move, but HUD estimated that there would be additional 60 fair housing complaints upon passage of it. I don't know. I saw some of these cases in employment, but haven't seen those as much when it comes to housing. There's key guidance. The EOC has guidance back to 1989. New York City Commission on Human Rights has guidance dating back to 2019, but it really mentions more in employment and public accommodation, not in housing. But that's something the centers, we could be testing that to see when it comes to if that's people are being discriminated against on hairstyles. In terms of the other fair housing updates, we talk about source of income. Just real briefly on tenant screening, algorithmic bias, criminal records and housing, national origin, reasonable accommodation and modifications, and damage awards. But then I'm going to really get Director Johnson to what suggestions can we do for Michigan law. So there's a bunch of them. So first on source of income protections, the only protection under federal law is under Equal Credit Opportunity Act. There's no federal protection. Up to 23 states, maybe more at this current time. Michigan has bills. I'll talk about that in a second. There's 16 cities at current count, 17 if Detroit is counted. Detroit has public benefit status. They don't use the magic word source of income. I talked to Poverty Resource Action Council for their Appendix B, so they are going to update it, so Detroit will get mentioned there, hopefully. You can see all of them that are listed here. Grand Rapids, they tell me, is not enforced as to vouchers. We go on to the next one. Couple problems. Local ordinances, you can see a listing of some of these. These exemptions really vary. Shockingly, Michigan House Bills 4062, 4063, and Senate House Bills for 2023, 205 to 207 exempts out landlords. The only landlords that would be covered are those with 5 or more rental units. The whole idea of exemptions is archaic. The exemptions got put into the Fair Housing Act at a time when Congress was not sure that it would be constitutional to reach purely private housing transactions. About 2.5 months after the Fair Housing Act got passed, Supreme Court Jones versus Alfred Mayer said that Section 1982 reaches purely private housing transactions without any exemption. So there is no exemption for race, color, ancestry, but for some of the other ones, there is an exemption, but that's really archaic. They shouldn't be there. We were in front of Pontiac, got Pontiac to adopt source of income with no exception like that as well. So the Mrs. Murphy, single family, all those things should not apply. I'm just shocked. It just seems lobbying efforts. That's all I can tell you. Our study, there was a Detroit report, not dealing with fair housing, but just dealing with the characteristics of property owners in Detroit. And majority of property owners owed 1 or 2 properties or 3 or 4 properties. 5 or more were very, very few. So it's roughly only almost like 2/3 of the properties, rental properties in Detroit are owners that have 1, 2, 3, or 4 unit properties. So you exclude out 67%. That's 4 or more. But 5 and above, like Detroit, in this bill, probably exclude close to 80% of the housing market. Plus, the added problem to this is you don't know if they're related entities. Many of them form LLCs. So how do you know if the LLC is a single LLC for a particular property? It could be to avoid liability or avoid Section 8, but it also could be for legitimate tax purposes, investment purposes. But it makes every single complaint into a big investigation, and people are not going to know if they're covered or not. And if the purpose is to make housing affordable for the most low-income community, why are we taking those houses off the market? Makes no sense. At some point, in my opinion, legislature, city councils have to step back, do what's right. You want Section 8? Make Section 8. Have it apply to all the properties. Won't kill people. I know there's, some may disagree with it. On local enforcement, Detroit only has voluntary conciliation. That's not going anywhere. We've got one where we got a finding of liability, voluntary conciliation, and nothing's happening. Not that anything could happen. Many of them have $500 fines. Ann Arbor, and we had in Pontiac, right of private action. In fact, Pontiac, in discussion with city council, they agreed to pull the city attorney out of the process at all, completely. They're just turning it over to the centers, for housing centers, or private right of action for enforcement. That's a good approach. So it's no drain on city resources at all. City attorneys really don't want to get involved in these kind of things. Plus, they don't investigate them very well. Not the way we do within the fair housing community. Our next one, enforcement guidance. New York State Division of Human Rights has great guidance on it. There's widespread violations. The Memphis report showed that. Often it's concealed race discrimination or overt race discrimination, but often it's subtle, right? They want income, wealth. You have to show $1,500 in assets. Most people on vouchers don't have that, or 600, 650 credit score. How necessary is that, especially if 100% of the rent is being vouchered? There can be high application fees and deposits. I just haven't finished the report, but we've done a source of income investigation as to all the cities in our service area that have, at least in the back, that a lot with that, with source in Ingla. Where's Ingla? Yes, they did great work on that, showing whether or not there's been compliance with source of income requirements. And sometimes it's what? A flat no. Sometimes they don't even know it's out there. So there is a lot of, even when it gets adopted, it's not a cure-all. It's not a one-fix-all, all the problem of affordable housing, adopting Section 8. On tenant screening, algorithmic bias, I've cited a case, Lewis versus Safe Rent Solutions. Doing great. You're doing great. Better than I would be doing. At the third subparagraph, it just gives the data. And the court found it sufficient to state a disparate impact claim. It said that black consumers had a median credit score of 612, Hispanic 661, white consumers 725, and therefore their policy, right, based on credit scores and that result in a disparate impact. Couple problems. Then they said they stated a disparate impact claim. We'll talk about more about this on the disparate impact panel this afternoon. The question is this: on the standard of proof, courts are split on this. Some say the statistic is disproportionately, a protected group is disproportionately affected by a challenge policy. Other courts take a real higher standard, almost impossible to meet. They require proof that the challenge policy caused the statistical disparity. In other words, you've got to show that that policy got adopted and to show what happened within the housing market as a result of it. If not, you don't have a case. That is such a high standard. Right, Lincoln Properties is one case. But what I would recommend is this: don't overlook whether the policy, again, it's an alternative one under HUD regulations, under the Fair Housing Act, whether it creates, increases, or perpetuates segregated housing patterns as to protective classes. That should not be overlooked. If you look at this policy, then you just look at the housing market as it is and say, well, you know what? If they adopt a credit score requirement like this, will it create, increase, or perpetuate segregated housing opportunities? That's a stronger basis, and sometimes that gets overlooked. People think of perpetuation of segregation, they're thinking about local zoning ordinances and not thinking about regular standard housing practices like this that can perpetuate segregated housing opportunities. So that needs to be, I would add it in here. We did have, Lisa mentioned to me, Safe Rent. Safe Rent said what about the decisions, Lisa? What'd they say? What did Safe Rent say when a tester contacted them? There you go. Yes, and the landlords will say, there you go. An endless circle and no liability, right? Join both of them. I don't buy that, right? Just I think there's liability for placing a discriminatory ad. There should be liability for doing what? Right, carrying out a policy that's going to be discriminatory. I posted a question, is it wrong to hold somebody liable for discrimination if they didn't really intend it? Is disparate impact a good theory, or is it unfair to housing providers in that? Answer is, that's what they say, the other side. No, it's not. And it's inclusive communities, Justice Kennedy addressed it. He said the Fair Housing Act has results-oriented language, 576 U.S. at 534. He also says, I'll quote, recognition of disparate impact liability under the Fair Housing Act also plays a role in uncovering discriminatory intent. It permits plaintiffs to counteract unconscious prejudices and disguise animus that escape easy classification as disparate treatment. So that's not a good argument against disparate impact liability. On criminal records, several bills are pending. A key one, HUD has a notice of proposed rule reducing barriers to in HUD-assisted housing. That's April 2024. Says a lot, right? Overall, they want to avoid categorical excluded, blanket exclusions of people with a criminal record policy. And it sets a look-back period of 3 years. Again, it's proposed, so we don't have it finalized. You can still turn somebody down for drug-related criminal activity, violent criminal activity, again, but it goes back 3 years, or other, whether activity bears on the health, safety of other residents or the PHA owner, contractors, et cetera, of the public housing. So there's a lot to be said about that. There's Michigan legislation on that. There's much to be done when it comes to criminal record requirements. I'll see. But I just think anybody that does not do it, there shouldn't be anybody, right, doing flat blanket policies when it comes to criminal record requirements. So that's, it's 146 pages, notice of proposed rulemaking. For time purposes, I'm not going to go into detail with it. A real helpful one, though, is, I think Sarah Pratt worked on this one, the conciliation agreement in Zuniga case versus residential property management has a sample criminal record policy, which is very good. Housing providers can just take that policy and adopt it and use it. That's a good way to avoid liability. There is, let me get it here. I got these out of order here. And again, why is the conciliation important? Well, because HUD approved it. It's a HUD-approved conciliation agreement. National origin discrimination, again, it's unlike, race now having a definition under Michigan law. National origin is not defined, but the Supreme Court defines it broadly. Espinoza is the standard place from which their ancestors came from, so it doesn't matter how many generations back you go. The Office of General Counsel has guidance on it. I like the EEOC policies. They're very, very helpful when it comes to national origin discrimination. But the key thing here, there's a model policy when it comes to national origin discrimination, describing what kind of required documentation a housing provider can ask for to confirm someone's identity, which they're permitted to do. And it lists 14 types, I think it's the next slide, 14 types of acceptable forms of documentation to establish someone's identity. where they can confirm somebody's identity without going into national origin discrimination. And next one is a case study. This Reyes case, gone back and forth up to the Court of Appeals. The housing provider was requiring original Social Security card, original foreign passport or visa to show legal status in the U.S. Again, if that was they adopted the Zynga policy, they would not have gotten into trouble with this liability. And then the next on reasonable accommodation modifications, courts always say, Professor Schwem always says, well, case by case, law really doesn't develop, but there is getting to be a group of things that housing providers do that can be clear-cut violations, denying right to a seeing eye dog, reserved parking spot, breed and weight restrictions on assistance animal, pet deposit fees, charges for assistance animals, for reasonable modifications. Grab bars are pretty well accepted. You know, it's hard to escape liability if you deny someone a grab bar when they need it, lowering kitchen cabinets, installing a ramp, requiring insurance coverage for modifications. That's a clear violation. And an example one is Southwest Fair Housing Council, where there was a challenge to refusal to provide a flashing doorbell. We've got a couple American Sign Language cases on appeal. The briefing just got completed on the second case. The first case has oral argument July 25th. Hopefully we'll get a good ruling on that one. Next, I want to talk real quickly about, I think I go into what I think should be, that's out of order here. Michigan law, what can we do? Well, there's recent damage awards. I think there needs to be more emphasis. For many people, they can't hire attorneys. Attorneys are not taking their fair housing cases, so the administrative process is all they have. If they don't do fair, fully compensable damage awards, then people lose out. There's two recent HUD decisions, HUD v. Drangton, HUD v. Ramos, where they had significantly higher than normal, right, compensatory awards, and those also cite many, many other decisions. That's very, very helpful. There needs to be kind of a national clearinghouse or emphasis when it comes to two things. Administrative decisions reached by FAP agencies nationwide, including HUD. HUD does report there. It's not in a great way, but they do report them, HUD LJ decisions. But there needs to be something done at the FAP level around various states, and there needs to be a collection of settlements and decisions. That's just information. I mean, a lot of the FAPs, and Michigan is no different than other places, they all sign to work independently. They may not know that there's been a great administrative decision in Illinois, right? It's kind of hit and miss. There needs to be some way to have that information available. Who suffers? Claimants suffer. On policy recommendations, I wrote, going back, first off, punitive damages. Shocking, Michigan does not have punitive damages. The proposed change is to add punitive damages. If you look at punitive damages are available under the Fair Housing Act. Here, I have that in the comments, right? And believe it or not, the absence of punitive damages in Elliott Larson and Persons with Disabilities Civil Rights Act violates HUD regulations governing substantial equivalency status. To be a substantial equivalent agency to receive case referrals from HUD, we are required to have punitive damages under our state civil rights law, period. HUD could, if it chose to, revoke every single referral, make no referrals to the MDCR because we don't have punitive damages, period. I wrote Director Scott years ago about it, and he said time wasn't right. And I don't know what that meant because they had Michigan Senate and Michigan House were Democrat majorities in both houses, right? And it wasn't the right time. This has to be done. The second thing is standing of fair housing organizations to bring fair housing claims need to have a provision under Elliott Larson and Persons with Disabilities Civil Rights Act where, for example, if we show through testing fair housing violations, it may be difficult at times to establish standing. Standing has always been under attack. There is, so I have proposed language to add to Elliott Larson and Michigan Persons with Disabilities Civil Rights Act to define persons aggrieved. This is kind of magic language. Go to the next slide. It's from New York. New York City's local law has that language to give fair housing organizations standing. Other organizations, nonprofit organizations, can have standing as well. Pontiac, City of Pontiac adopted that language. And they did so with the fact that they want us to be involved in the enforcement of it. So it's something that really, I think it's really, really necessary. So can HUD bring a case? Certainly. Can the Michigan Department of Civil Rights bring a case? Yes. They have statutory standing. So you don't get into all of those arguments. You just deal with the merits of what the violation is, and the steps can be taken to conciliation, or if it has to go to a trial if necessary, and so it can get corrected. But we will spend hours and hours forever dealing with the standing issue and never really address the underlying fair housing violation. So that's, certainly I would want that to occur. A third suggestion has to do with statute of limitations, tolling and continuing violations. It may be surprising under the Fair Housing Act, there's tolling. During the time that administrative complaint is pending with HUD or a local FAP agency like the Michigan Department of Civil Rights, the statute of limitations is tolled during that period as to the Fair Housing Act. There is no tolling under Michigan Persons with Disabilities Civil Rights Act or Elliott Larson Civil Rights Act. How this happens, I had a disability case, and it was processed, took quite a bit of time, and it was like 2 years, it was at 2 years, 11 months, and I thought, well, I just assumed it was a disability case. I just assumed that there was also a Fair Housing Act claim. Just because you file a disability claim with the Michigan Department of Civil Rights doesn't necessarily mean that they've taken the steps to get a HUD number, so that it's been dual filed under the Fair Housing Act. Turns out it wasn't, and what had happened is they referred it over to HUD to have a HUD number on it so the Michigan Department of Civil Rights could get funded. HUD rejected it, and without going into detail why, it was really unfounded. It was not, the department was not in agreement with that. And so after that 3-year period, right, there is, I'm sorry, it was already close to 3 years, right? So there was no Fair Housing Act claim at all. There's no punitive damages at all. The only claim that was left was the Persons with Disabilities Civil Rights Act claim, period. And again, there's no right at that point even to go into court, right? Because we're up against a 3-year limitation under Persons with Disabilities Civil Rights Act, right? So all these are problems. Just simplify it as do this. Put a tolling provision in it when it comes to claims under Elliott Larson and Michigan Persons with Disabilities Civil Rights Act. Another thing is there's been some debate about continuing violations. That is certainly rock solid under federal law, under Havens. It needs to be made clear, and I don't know why this is being challenged, but there needs to be clear language about a continuing violation. We go to the next one, right? As long as there's one act of discrimination within the limitations period, 180 days for MDCR, then that should be sufficient to go back and get prior violations should count. That's the accepted standard. But it's not, the Guard case deals with the statute of limitations, it's not a tolling case, right? But they overruled continuing violation, but that needs to be made clear. The Fair Housing Act requires it. If the department is not following it, then they're not, again, substantially equivalent. It has to be interpreted the same way as the Federal Fair Housing Act. The next one on post-acquisitional claims, this Estate of Ramig case, which basically said under the Michigan Persons with Disabilities Civil Rights Act, a claim for a reasonable modification has to be brought at the time initial occupancy occurs. If it's made later, it doesn't count. It's not covered under the statute, which is flat wrong under federal law. I don't even think that's a correct interpretation of that. But the case ended up getting reversed and remanded by the Michigan Supreme Court on collateral estoppel grounds. But the Court of Appeals in October 2022, said that we still think this is correct, that it should be dismissed. Pam, Nancy, myself, all of us in the centers, we came up with our study on it. We found that as to reasonable modification claims, about 80 to 85% of those are made after someone is in the unit, and then later through aging, injury, disability, whatever, then they have the need for a reasonable modification. So this is not a small issue, it's a major issue. And actually that issue creeps over into the reasonable accommodation context as well. The Fair Housing Act and regulations are ironclad, rock solid, that reasonable accommodation claims and reasonable modifications claims can be made post-acquisition. There's no reason for Michigan to go the other way. There's language in Persons with Disabilities Civil Rights Act, property occupied or to be occupied. And the Court of Appeals decision crosses out occupied like it doesn't exist. That's just flat wrong of the statutory interpretation, but amendment would be good to clarify that. I have some on appeal rights. Number 5, we can jump to appeal rights. It's too long of a process, right? The Court of Appeals does not have a jury chair. Why? Because the trial and the evidence and the testimony is taken at the district court level, right? And so when there's a HUD administrative hearing, it occurs before the HUD administrative law judge. It gets reviewed by the secretary of HUD, assistant secretary typically would delegate it, and then it goes straight to the Court of Appeals. The court, there's no need for testimony, there's no need for a witness chair, none of that. It's a one-shot appeal. The second appeal at the Supreme Court is discretionary. Under Elliott Larson, there's an administrative hearing before a hearing officer, then it goes before the Michigan Civil Rights Commission, then it goes to circuit court for a de novo review. De novo is fresh without any presumptions or any deference to fact-finding by the administrative law judge or the commission. Then it goes to the Michigan Court of Appeals. It's too many steps. It's too burdensome. So they need to eliminate the circuit court appeal process. After the Michigan Civil Rights Commission issues a decision, it should go straight to the Court of Appeals to speed up that process. It's already way too long. And I think, let me see if I have one more. I think that's, those are the main things that I have, right? These are not, I don't think these are small changes. I do. Another thing I would like to add, one little comment too, when it comes to the hearing officers, really a need to train and recruit hearing officers. They have to be qualified, they have to know civil rights law, right? They have to be really qualified to do the cases, adjudicate them properly. It's nothing will destroy the administrative process unless, here's a difficulty about in civil rights enforcement, every step must work. From intake to investigation, to filing a charge, to having a hearing, to having a review. If there's a failure at any step in that process, people's rights are lost. They're not enforced. And so it's really difficult to see all the work being done to intake, investigation, cause finding and everything, only to have it fail because it's not effective when it comes to the hearing officer level or on the review level. And that's really, really unfortunate. But that's the challenge that we face. Every step along that process works. If there's no meaningful enforcement in a decision, respondents know that. They do not come to the table because they do not respect the process. And it's sad. I remember many times to get a case to move, while it's pending before the Michigan Department of Civil Rights, I would just up and file the case. Also, you can do both proceedings at the same time, but I'd file the case in federal court with a punitive damages demand, and then suddenly the conciliation process through the MDCR goes better. But that shouldn't be necessary, right? There should be enough clout, right, enforcement strength that you can bring respondents to the table and get meaningful resolutions of these cases. Thanks.
Thank you, Tim and Steve. Those were very well-done presentations, and obviously a very dense topic. We're talking about the legal updates. Both of these presentations are on the Hoover app for those who've downloaded it, so I know we were cruising through a little bit, and there's a lot of information. So look at the Hoover app. You can look at these presentations, get some of these cases, get some of this information. So we're running a little bit behind, but are there any questions from anybody in here for the panel? Sir.
I was floored by the news you presented. The latest presenter did a great job. My question still remains about some good strategies to try to address the issues that he brought up concerning the officers who will be able to monitor all this. What steps should be taken to at least put together a good charge and go after this and help clean this up so people can have their rights and be able to live in the state of Michigan as they should, as with equal protection under the law?
Just simple, I guess, I'm sorry, could you hand them back there? I'm not necessarily understanding your question. You're like, the most immediate steps you would say to get the
Yes.
process going? Do you have an opinion as to the priority of steps you would like to see changes?
Yeah, I mean, you have a director, Johnson, who has legislative background and experience, so that you're fortunate with that, knows the process. And you can notice like a theme on each of the presentations is what are some legislative suggestions or what can we do to be more effective? So I think we have an open ear to that. There's a legislative department or division within the MDCR. Jerome Reed, I think it's Jerome Reed that heads that. But yeah, we have to prioritize this. I just get shocked. You know, in Pennsylvania, they revoke substantial equivalency status in discriminatory advertising cases because they didn't provide, through court decision, didn't provide for punitive damages. So it's not a small priority. It should be done. It should have been done years and years and years ago. And not only, again, we're not only talking about housing, this spreads as well to employment, public accommodation, everything within the Civil Rights Act should have punitive damages. Again, you don't get punitive damages in administrative proceedings, but you do get punitive damages in court proceedings. And people shouldn't be forced to navigate through the EEOC process when they can directly get punitive damages under Michigan law. So yeah, this is just pure talk unless we do concrete action. You're right. These are important steps. They need to be done.
Any other questions or comments from in the back?
Has there been any work on removing barriers to reasonable modifications? I work for Disability Rights Michigan, and we're starting to hear a lot of cases where property owners are putting up barriers like requiring agencies to pull permits, draw up all kinds of extensive architectural plans and that sort of thing just to do like a rent modification. And so they're not denying the modification, but they're putting up so many barriers that it's making it very difficult for the volunteer organizations that would like to help people out to actually do their job.
Are you suggesting that municipalities are putting up barriers for, or the companies or the landlords?
It seems to be the management companies. We're seeing it a lot in manufactured home parks in particular, but it has been some other areas that the property management companies themselves have put all of these policies in place that is hindering people getting the reasonable modifications that they need.
Understood.
I mean, Pam and I dealt with a case, and she's nodding her head, where they said, well, you have to pull a building permit and go through other, various things. It turns out because it was above ground ramp, it didn't require a permit. And turns out factually, they never made a request to the city for that. They just threw it up like you're saying. But that's a denial of a reasonable modification. Yeah, where they're not going to come out and say no, but they're going to put so many barriers or obstacles when you know what the bottom line intent of that is, to deny somebody their reasonable accommodation. Or insurance requirements is some. There's a variety of ways that those get old, right? But they're violations. They should be reported. And now when I talk about standing, it'd be the standing of your organization to bring a claim like that. Because look how it impairs your efforts. Not only their rights are impaired, your rights. You can't serve your clientele when you're getting thwarted like this. So you actually are an injured organization when it comes to these practices. Again, if we could address that squarely in Michigan law, you would have those rights as well. And then when you make contact with a housing provider, they will probably then listen to you. That's what needs to be done.
You have time for one more question, ma'am?
I just had a question. If anything was coming down the pipe about housing association, like condominium associations, and the type of power that they have, because you get into a condominium association, you sign certain documents, and it seems like they oftentimes prevail in situations where you need a reasonable accommodation of something of that sort. So is there any type of legislation for something like that?
I personally am not aware of any. I don't know, Steve or Tim.
We need some.
Yeah, I'm not aware of it, but I will just say that, 2 years ago, and there are many other examples, we brought a case in Philadelphia against a condo association that was one of the, basically the leading high-rise condos of the city of Philadelphia for refusing to make accommodations for assistance animals. They, fought us every step of the way, and at the end, the jury found that they had engaged in a pattern of practice of discrimination. So the condo association doesn't always win.
And liability should attach not strictly to the condo association, makes many people pay, even innocent persons, but it should attach to the individual owners. Co-ops are another problem as well. Co-ops in the ideal world can be very, very effective, but they can have overbearing property management companies in that. We got a grant through Oakland County and then Kirk in the Hills to do tenants' rights and responsibilities training sessions to deal with people so that they understand, to know, hey, they need to get somebody on there, run for the board who's really for the residents or what their rights and responsibilities are. So that not only covers fair housing, but it covers a whole wide spectrum of landlord-tenant rights and laws and protections. All the rights in the world mean nothing if people are not aware of them. And it's a real challenge reaching individuals to know what their rights are. On our website under services and resources, a whole big chunk of landlord-tenant resources in that, because that's real, real important. MISTA is really big on that too, tenant rights, because many tenants, and then preventing fraud, many people fraudulently taken advantage of. People live in a co-op for so many years, and then when they go to sell their unit, they don't get any money out of it. It's just so that's a real problem as well. But I think, sue the individual people who are doing the act of discrimination, as well as the condo or co-op board. But you're right, that is a major, major issue, major part of violation. I did a training for one condominium group, and they said, well, we're not going to give assigned parking spots. Well, here's the regulation, here's the guidance. Yeah, but we have too many requests. We're just not going to do it. And they said, we're in full compliance with fair housing. And that's their final answer. I said, okay, you get a claim like that, it's on you. That's all I could say.
And then with that, I think we'll end it there. It's just a matter of policy changes as recommended by the panel, but a more effective enforcement of the laws we have on the books. So we have lunch now for everybody at noon. Thank you for being with us. One more round of applause for the panel here for their knowledge. Thank you very much.